So very big judgment has come up of the Supreme Court. So we'll be looking at that, and that Supreme Court's verdict on, states' rights to tax the mineral rich land. So the issue of course was related to this. The judgment has come. We'll see the historical background, what was it all about, what judgment was given previously and what is the case now. So if generally we have to understand, when it comes to mineral rich lands or taxing the mineral rich lands, the thing is, now the Supreme Court has said that the state government have unlimited power to tax the mineral rich land. Right? They have unlimited power to do so. Parliament to an extent can regulate to an extent that there is no blockage or hindrance in the supply of minerals, but the power to tax the mineral rich land lies with the state government, and in that they have unlimited power to do so. So these two are important concepts, important things you should remember. So what is the news? Supreme Court judgment has come out. So what has it ruled? That states have unlimited right. States are having unlimited right for what? To tax mining lands and quarries. Mining lands and quarries. And this right that they have, see, understand the psyche of UPSC questions. They would give everything same, just change one single word. What they will do, they will say the Supreme Court ruled that states have the unlimited right to tax mining lands and quarries based on the Parliament's Mine and Minerals Development and Regulation Act. So that would be wrong. Why? Because Supreme Court has said independent of the Parliament's Mines and Mineral Development and Regulation Act 1957. Okay. So this has to be remembered correctly. Why independent of it? Because the, imagine central government's law. So will central government generally be talking about giving unlimited rights to the state? No. That is why it would not be in sync. That is why Supreme Court has separated it and said that states have unlimited right to tax mining and land and quarries, which is independent of the provisions which is mentioned in the Mines and Mineral Development Regulation Act of 1957, which was brought out by the Parliament. Now this decision was taken by the constitutional bench of 9 judges. So it was a huge bench, of course, 9 judges bench, and the decision was taken 8:1. So 8 people are in agreement, 1 person was in disagreement. We will see why that disagreement, from what that disagreement stems from. Okay. Also, one reason they have said is that will help the state government for revenue generation. So revenue generation for state government will be helped if we do that. Now, what is the historical background of this entire issue? In 1989, a 7-judge bench. Okay, so how does the hierarchy work? If there was a 7-judge bench, now to supersede that decision, either you have a 7-judge bench only which gives with in majority or whatever the decision is given. So 7-judge bench can be superseded by a 7-judge bench also. How? Because this, so which judgment will be considered? The latest one. Basically the latest judgment is considered. But can a 7-judge bench be superseded by a 5-judge bench? No. So you could not have formed a 5-judge bench. You could have formed 7-judge bench and it would be the latest decision, so it would have superseded. But directly they had formed a 9-judge bench for this particular issue. Previously what happened? 7-judge bench was there, and what did it say? It said that states could only collect royalties and not impose additional taxes, as royalties were classified as taxes. Now understand this entire sentence or the judgment of the Supreme Court. At that time, Supreme Court considered royalties as taxes. So one form of taxes. So Supreme Court considered royalties as one form of taxes, and it said that only royalties can be charged by the state government, other taxes cannot. Right? So states could only collect royalties, not imposed additional taxes. Why they are saying additional taxes? Because Supreme Court at that point is considering royalty also as a tax. So it said one form of tax you are charging, now don't charge other additional kind of taxes. We have given you the authority to charge this tax which is royalty, don't charge additional tax. But present Supreme Court judgment says that boss, royalty is different, tax is different. That means the previous judgment did not allow state government to charge any tax whatsoever because royalty is not a tax. We'll see how that is not a tax, we'll understand that as well. So remember, earlier the judgment considered royalties to be taxes and only royalties could be charged, additional taxes could not be charged. This judgment considers royalties and taxes to be different altogether, and that is why thinks that there was no power to tax with the state government. So now they have given it the unlimited power. Okay, in 2005, judge bench suggested there might have been a typographical error. So they themselves had accepted that there might have been a typographical error because of which this has happened. So imagine with small issues may not be actual decision but a typographical error which has led over decades, and now the final conclusion is about to come. Okay, so what has been the judgment and what it does, let's understand. So Supreme Court's judgment, first things first, State Taxation Authority. So it has clearly said the power to tax mineral rights is enumerated in entry 50 of list 2. List 2 is state list, and Parliament cannot use its residuary power with respect to this particular subject. What is residuary power of the government? Residuary power is anything which is not mentioned in either of the three lists, the state list, the concurrent list or the center list, that becomes residuary power. So you cannot use those kind of things, residuary power, to override this particular provision which is there. It also says though states can have unlimited taxing rights, but Parliament can impose limitations. Parliament can impose certain limitations. For example, if taxes are going too high, there is level of sort of profiteering, and if the taxes are going too high that the product is costlier, right, the minerals that are coming out is costlier, which is leading to, let's say, low production, low purchase, etc., but the economy requires, India requires for its development. So if there is a hindrance in the production of minerals because of that, then the Parliament can impose restrictions, of course, okay, can impose limitations on states' mineral taxation via laws. MMDRA has no specific provision imposing such limitations. Why MMDRA has no such provision imposing limitations? Because Supreme Court has said it is independent of MMDRA. But government can bring in some law or impose certain limitations if it deems necessary, right? Regulatory power. Now entry 54, that is in the union list, pertains to union's power over mineral and is regulatory, not inclusive of taxing authority. Very important. So Supreme Court here says the entry in the union list, the 54th entry in the union list, is regarding regulation and not taxation. So this is also made clear. All these sentences could be formed as prelims question statement. Okay. Definition of land. Land in entry 49 includes mineral bearing lands also. So in land in entry 49, it talks about taxation on land. So it has now said that this land includes mineral rich land also, automatically saying that mineral rich land can also be taxed by the state government, granting states the competence to tax such lands. Simply what you have done, entry 49 talked about land, you simply said now this land also includes mineral rich land also. The moment it includes mineral rich and land also, there was already a provision of taxation. So now you can tax mineral rich land as well. And of course it has overruled the 1989 judgment holding that royalty is not within the nature of tax. Okay, these are two different things. Now, there are some certain clarifications also mentioned. The ruling clarifies that power to impose taxes on mineral rights resides solely with the states. So it is very clear, re-emphasis is being given that state has the overriding sole and unlimited power for that. Ensuring non-obstruction, of course, to ensure non-obstruction, Parliament can set certain restraints on how the states levy the taxes on minerals so that the development, mineral development, production, etc. is not hindered. Sorry, that was a repeat. Now let's understand the difference between royalty and tax. A lot of things would look repetitive, but we'll still try to understand from different perspectives. Okay, so what is royalty and what is tax? See, royalty comes from an agreement between two parties. You have created, for example, an album of songs. You put your album, or you have created a book. You have written a book, you go to a publication house and give them money to print, let's say 1 lakh books and put it in the market. So what happens is the publication house will take the entire money of that book. What you will get is the royalty. And this is happening based on the agreement between the publication house and you. It is not that you went to the publication house and said that you have to give me this much royalty no matter what, whether you agree or not. Or the production house did not come to you and say that I will give you this much and you have to write a book and you have to do this. No, both are agreeing and then you are going ahead. So that is what royalty is. Its origination is from an agreement between parties. Is that the case with taxes? Of course not. Of course not. The government simply imposed. Did government come to you, decide, you had a discussion and then we decided this much tax should be imposed? No, it is not mutually agreed thing. It is an imposed thing. So imposed, it is imposed under a statutory power without reference to any special benefit. There is no benefit, right? No benefit as in indirect benefits you get, let's say roads are constructed, but no specific benefit, you pay this much tax, I'll give you this much. It's nothing like that. Someone paying no direct taxes also uses the road. Someone paying very high direct taxes also uses the road. Someone paying some less amount of direct taxes also uses the road. So there is no specific thing, you pay 10 rupees, I'll give you this. You pay 100 rupees, I'll give you this. So there is no agreement and it is basically imposed. That is the major difference. So nature compensation is paid, of course, certain privilege, both the parties are getting benefited directly. It is enforced by law, does not require taxpayers' consent. Your consent is not required, right? Now, direct relationship with the benefit or privilege conferred upon the grantee, imposed for public purposes without any specific benefit to the payer. Rather, more benefits would go to the socio-economically backward who may not be able to pay direct taxes. And rightly so, they are poor, they need, the society should function in unison together with solidarity, all that is good. We are simply trying to understand the difference between the royalty and taxes. Often linked to exploitation of resources or usage. This is linked to how many books are sold, right? Part of the common burden borne by all citizens, not linked to any specific privilege or benefit, not linked to any benefit. Again, they are repeating over here, but this is important to understand that the more books are sold, the more money you get. Okay, involves quid pro quo arrangement, does not involve a quid pro quo arrangement. That means predefined arrangement is there. Boss, one book sells of 200 rupees, 20 rupees you will get. That means 10% loyalty you will get. Here 1 lakh tax you pay per annum, you will get this. No, nothing is defined. There is no quid pro quo, no predefined rules, regulations and benefits, nothing like that. So that is the difference between royalty and tax, which earlier Supreme Court had said it's same, but now it has clearly mentioned that royalty is different, tax is different, and the state government can impose tax completely. Now, as I said initially that there is one of the criticism, one of the judges had given a judgment against it. So it is 8:1. So what that judge has said is basically, that honorable judge has said is, basically what was said is, the thing is that if you do this for one particular thing, it may have a domino effect and it will override the power of the center basically, and more states will start coming in different things, right? One more, payment is linked to a specific benefit. Again, payment is mandatory, fine. There is no much difference. But let's look at the dissenting judgment. The dissenting judgment said that if we do this, it will open Pandora's box, and tomorrow taxation on some other thing in the similar manner may be put forward, and that is going to erode the power of the parliament, of the central government to impose taxes. So that was one argument. Now the issue with this argument is very generic. It is not based on the let's say merit of this particular case. It is based on the fact that in future something can happen. So that is one criticism of this judgment itself. But of course, it is also a thing that it may create a domino effect, it may open a Pandora's box, and the states may try to fight various other cases for imposition of taxes and various other things as well. Thank you.